So without any further ado, let me get into it. I hope Cathleen hasn't run away. I see she's still muted and her camera is still off. So thank goodness. Right, Cathleen, you are here. It's great to see you in the meeting. Right. So folks, obviously, as we know, losing a loved one can be a very, very traumatic experience. This is very frequently compounded by the uncertainty and the secondary trauma of being faced with an executor who is not fulfilling their duties in good faith and to the benefit of the beneficiaries, either named in a will or via intestate succession. Kathleen is going to be looking at, in very, very broad strokes, the duties and the obligations of executors, signs of malicious conduct, some of the consequences of malicious conduct, and then in very broad strokes, the remedies available to interested parties to ensure that their interests are protected. This will most probably be the first in a series of webinars on the topic, so we are going to be doing a fairly broad overview of the topic. However, if you would like me to address anything in a bit more detail in the comment box, please do pose your questions and we will deal with them accordingly. So it is my absolute privilege today to introduce to you Cathleen Breedt. She is a litigation attorney who does a lot of work in the realms of deceased estate matters. Kathleen, can you hear me? You are still muted. Unmute yourself. You're not getting off the hook that easily. Great. Lovely. Kathleen, over to you. Please, guys, give Kathleen a very, very warm welcome. You are welcome to use your reaction button and thumbs up and heart and laugh to your heart's content. So over to you. Thank you, Kathleen.
Morning, everyone, and thanks so much for the opportunity, firstly, and also for everyone spending some time with us today. So yes, today we're discussing a little bit more about dealing with a malicious executor. For those that are not familiar with the term executor, what exactly are we talking about? Why are we here? So firstly, an executor in this discussion is an executor as one would have in dealing with a deceased estate. So an executor is a person appointed in a will or by the Master of the High Court to administer the estate of a deceased person. They're responsible for gathering the deceased's assets, paying off the debts and taxes, and distributing the remaining assets to the beneficiaries named in the will or determined by law. So there's just another pinpointed view of what is an executor. Let's go forward. So two types of executors that we deal with. Firstly, we deal with executors who have been appointed in a will. In other words, the testator has put in the will, I need person X to be my executor. Usually it would be a financial advisor or a family member or sometimes even an attorney. Say, this is the person that I want to have execute my will. Just as a point of interest, usually when an executor is appointed in the will, it would be someone related or a close friend of the person who is actually, or the testator. But also a good idea would be to add an attorney, a financial advisor, or someone who actually has some insight or knowledge about how to execute a will. Most of the time that is done, but for those that are not, it makes it quite difficult because that leaves the person that has to execute the will with no knowledge of how to do so. Then the second type of executor we have is an executor dative. This is an executor that's appointed by the Master of the High Court. So this is where there is no executor appointed, alternatively when we're dealing with an interstate estate. What are important preliminary concepts in terms of executor? So an executor testamentary, that is what I've just discussed. This is someone who's been appointed by the will itself. The deceased person picked the person they want to execute the will, and they've nominated that person in writing in the will. This person must still go to the master and still get a letter of executorship from the master to be properly appointed as the executor of the will. It's not as easy as you're named in the will and you can just go for gold. Then an executor dative is in the absence of an executory testament or an executor having been appointed by the will. Obviously, the will cannot be be resolved. So then the master has to step up, will step into the space and then appoint the executor dative. Security. So in a lot of wills, you'll see that the person actually specifically puts in there that the executor will not be required to provide security. But this is something that the master usually will require. This is for obvious reasons. Obviously, if we're dealing with an estate without a lot of money in it, and then the costs go escalate, or there are legal actions instituted against the will, or that obviously secures the master so that these people have someone to go against if something happens. But usually in the will, the testator would actually say that they will not require the executor to give any form of security to the master. Okay, documents. The documents required for obtaining the letter of executorship. It depends on the type of will, it depends on a lot of factors, but usually it would include the death notice, the will itself, the acceptance of trust, the inventory of the estate, and a completed bond of security. An executor may assume a co-executor to act with him in the administration of the estate, provided he is expressly given this power by the will of the deceased person. Like I said, most of the time an executor is someone that you know, it's a family friend, or it's your brother, it's your sister, it's your child. This person has no knowledge of actually executing a will, and therefore usually the will contain a clause to say that this person can actually appoint a co-executor, someone who's knowledgeable in estates, in order to assist them in so executing. What are the powers of executors? So first and foremost, the executor is tasked with gathering all of the assets. So this means physical assets, bank accounts, all form of assets that the deceased person had. It also entails if some of the assets are sitting with other people, to go and collect them, whether it be by legal action if it's not willingly provided, or alternatively just literally going and collecting it. In the second place, the executor is tasked with payment of all debts that are in existence at the time of the person dying. This also includes a whole process of instituting claims against the estate. So the winding up of an estate is quite a lengthy process. So it does allow quite a lot of time for people to come forward. But let's say, for example, you owed your brother money. It's not something in terms like a bank account or something that's easily ascertainable. This person can institute their claim against the estate. And obviously that is also part and parcel of the executor's duties, is to ensure that those payments are done once the claims are accepted. Then the management of the estate. The executor has the power to manage the estate, including the power to lease or sell estate property, and to invest estate funds in accordance with the provisions of the will. Like I said, the winding up of an estate is quite a lengthy process. So if you're sitting with immovable property at the time of your death, obviously you don't want the immovable property just to sit empty. It's best for that to be leased out, and then obviously some money will come into the estate. So that is one of the things that the executor can, one, decide and then obviously manage. And then, of course, distribution of the estate. So once all of the assets has been collected, all of the debts have been paid, there is a residue that has to be distributed to the beneficiaries. And that is obviously also part of the executor's duties. Okay, mortgaging and pledging of estate property. The executor may not mortgage or any immovable property of the estate without directions to that effect in the will or the sanction of the courts, unless it's to the benefit of all parties interested. So, I mean, this goes without saying. If there is immovable property in the estate, going and getting a second bond on the immovable property can't be just be done with just for the sake of it. It has to be specific circumstances surrounding, and obviously, like we said, to the benefits of the parties interested. That would mean your beneficiaries. Then if an executor or those connected with him desire to purchase any of the estate assets, so that's if the executor or himself or someone who's closely related wishes to purchase assets, the purchase shall be void unless it's been consented to or confirmed by the master of the High Court. This also goes without saying. It's just to cover any loopholes so that the executor doesn't purchase all of the state's assets for little to no money, and then obviously leaves very little to be distributed to the beneficiaries, if anything. The executor may not absent himself from the Republic for a period exceeding 60 days unless he's been granted permission by the master. it complies with the imposed conditions of the master and has been given the required notice or has given the required notice. So, like I said, the winding of an estate is quite a lengthy process, but it's also quite an involved process. So naturally, one could understand that an executor can't just be AWOL out of the country for 60 days, because obviously then he can't be performing his duties. If any default is made in the faithful administration of the estate by the executor, the master may enforce the security recovered from the surety, the actual loss to the estate. So this is quite involved, because what it means is that your executor, when providing the security, also binds himself as a surety. So it's good for the beneficiaries, not so great for the executor if he's not feeling like doing his job properly, obviously. Okay, what are the obligations of the executors? We touched on this in broad terms earlier, but let's go into a little bit of more detail. So one is to determine and secure the assets of the deceased. The executor is responsible for identifying and safeguarding all assets of the deceased. Like we spoke about earlier, sometimes it will happen that, let's say the person who's deceased was a father and his child was driving the car that's actually his asset. Obviously, that car has to be taken into possession by the executor. So that's part of the gathering of the assets portion of the execution of the estate. And obviously, first and foremost, they need to identify what assets are actually in the estate. So that's also quite an involved process. Then secondly, they need to pay all of the debts of the deceased. The executor must pay all outstanding debts of the deceased, including taxes and funeral expenses. So this would mean debts that are already in existence at the time of the deceased passing away, and also expenses in the actual estate that pop up, like we said, the funeral expenses, and then taxes, obviously. Quite a lot of tax implications in life. Then they need to distribute the assets. The executor must distribute the assets in the estate in accordance with the terms of the will, or in the absence of the will, in accordance with the law of intestate succession, which is not a lovely process to follow. So best to just get your will in place. So this literally means that if the person said, my children will receive the proceeds or receive my entire estate in 50% portions, they need to determine and literally split up, after selling all of the assets off, literally split up the money between the two. Obviously, it gets way more convoluted than that, but that's the basic principle of it. And then this is the important thing, and I think this is a crux of our webinar today, is they need to act in the best interest of the estate. The executor is a fiduciary and must act in the best interest of the estate and its beneficiaries. So, like I said, we're going to go into way more detail on this one, but I think that is a very important thing to take note of, is the executor has a function, it's a job to do. It's not something that they must gain any privilege or luck from. It's something that they literally have to proceed, or they have to do with the utmost care and fiduciary duties. Okay, they need to keep accurate records. This is something that executors usually are not great with, especially if it's not an attorney, of all transactions related to the estate, including receipts and payments. Then further, they have to file tax returns in respect of the estate. So this would include tax returns for prior to the death of the deceased, as well as the taxes relating to the actual winding up of the estate. Then they have to provide security. The executor must provide security in the form of a bond to ensure that the estate is protected against any loss caused by the executor's actions. So obviously, losses caused by the executor's actions, again, this is what we're going to go into detail today, is ideally there aren't any losses resulting from any actions of the executor, in him just performing his function. But I mean, life happens, and sometimes we do face these types of things. So in that event, there must be a bond of security to ensure that the estate at the end of the day is not sitting in a deficit due to the executor's lack of action or action. Then the executor must provide periodic accounts to the Master of the High Court detailing the administration of the estate. So this is where we find a lot of issues in the estate litigation with, is the executor literally sitting back doing what we assume to be nothing, and then also not complying with all of these accounts. They have to refer to the master, and obviously this is a good cause for an executor to be removed from the execution of the estate. We'll get into that in more detail now, though. So what makes executors go bad? Several reasons, obviously. So firstly, we've put their greed. Executor may embezzle funds from the estate or charge excessive fees in order to enrich themselves at the expense of the beneficiaries. Just as an FYI, executors have a prescribed rate at which they can tax or at which rate they can claim their fee from the estate. Usually it's around 3.5%. It is negotiable though, so some of them do go lower, but according to legislation, they're allowed to claim a fee of 3.5% of the total estate value. Then influence. The executor could be unduly influenced by a friend or family member who stands to benefit from the estate, so in other words, a beneficiary, and may make decisions that are not in the best interest of the beneficiaries as a whole. So let's say the executor, for example, is the brother of the deceased, and his wife will inherit some money. They could make decisions to benefit themselves and the wife rather than making decisions for the beneficiaries as a whole for the global. Then cover-ups. The executor could attempt to cover up mistakes or wrongdoings by withholding information and providing false information to the beneficiaries or the master of high court. As is life, unfortunately, it happens quite often that we make mistakes, and obviously attempting to cover those mistakes up usually end worse off than just admitting to it. But obviously, if you're in a position of executor of the estate, you don't really want to admit when you did make a mistake. And then conflicts of interests. An executor may have a conflict of interest, such as being both the executor and a beneficiary of the estate, and which may lead them to make decisions that are not in the best interest of the other beneficiaries. Like I said, most of the time when we do appoint a beneficiary, an executor to our estates in the will, it would be the obvious decision to make it someone who's close to us, which usually means that this person is also a beneficiary to your estate. So that obviously opens the door in terms of conflict of interest and potential wrongdoing by the executor. Then negligence. An executor may be negligent in their duties, such as failing to properly invest estate's assets or failing to pay debts on time, which may result in financial losses for the estate. And then obviously dishonesty. An executor could be dishonest in their dealings, such as by failing to disclose all relevant information to providing false information to the beneficiaries or the master of the High Court. And naturally, we don't want to be dealing with something like a dishonesty, but it does happen, unfortunately. And then some aspects which are not necessarily malicious, but are still damaging to the winding up of an estate is both inexperience and incompetence. Inexperience, obviously, it could be an attorney that's very newly admitted or an attorney that takes on an estate matter that doesn't really do estates very often. Or alternatively, like I said, a lot of people like to appoint their financial advisors as the executor, but these people don't necessarily have the necessary experience to actually deal with the winding up of an estate. And obviously that opens a lot of doors for errors to be made. And then incompetence, very much the same, but not entirely. But I mean, incompetence, literally someone doesn't know what they're doing and they make mistakes all the time. And they don't, at the end of the day, they don't fulfill the wishes of the testator in a way that they meant to. So how do we identify malicious behavior? Like I said, we need to understand that the winding up of an estate does take quite a lot of time. So the beneficiaries inevitably will get frustrated and inevitably will get to a point where they feel that the executor is not acting in their best interest and in the interest of the winding up of the estate. It's not necessarily the case, however, especially for us not dealing with estates every day. We don't understand what the processes entail. We don't necessarily believe that the master could literally strike about 4 times in a month, but it does happen. So how do we spot when the behavior or the delays or what is being done in the estate is actually malicious and not just South African public service? So one, a lack of transparency. So malicious executors would usually avoid providing information or documentation to the beneficiaries or the heirs. Naturally, if you're trying to cover something up, you're not willing to disclose documents, so that should be a sure sign. A refusal to communicate. Again, when you're sending email after email after email to the executor of your deceased person's estates and receiving nothing from them in return, no updates as to where the estate is or the winding up of the estate is, obviously that is a massive red flag and something to cause concern. Then misrepresentation. The malicious executor may provide false or misleading information to the beneficiaries or the heirs, or make false statements under oath. So this is where it gets a little hairy, because obviously the beneficiaries and the heirs don't know what's being represented, nor do they usually know what the truth is. So this is where usually you'll go on a gut feel, but where some deeper investigation has to be done in terms of what the executor has actually done, uplifting the master's file to see what documents have actually been filed, and really going and doing an in-depth investigation into what has been done in the winding up of the estate. Then self-serving actions. A malicious executor may prioritize their own interest over the interest of the estate or the beneficiaries, and may take actions that benefit themselves rather than the beneficiaries as a whole, and obviously at the expense of the other beneficiaries or the beneficiaries as a whole. Delays. Like I said, this one is a bit of a hairy one, especially since we are dealing with massive delays in terms of winding up of estates already. But a malicious executor may delay the administration of the estate and prolong the process unnecessarily and cause stress and expense for the beneficiaries of the heirs. When we have a doubt of whether a delay is being caused or whether there are delays being caused, it always is best to just chat to an attorney before to see if it is a delay first and foremost, or if it's just the master taking their time. Like I said, unfortunately, it does take quite a long time to wind up an estate. Then what are the consequences of malicious behavior by executors? So first and foremost, it's the delay in the distribution of the assets. The assets in the estate can only distribute to the heirs and the beneficiaries at the time that the estate has been wound up. So there's no interim payments unless it's for interim maintenance, but this is a topic for another day. So in other words, if your deceased loved one has passed away and 2, 3, 4 years down the line only is the funds paid out, that's quite a dire consequence to face for the beneficiaries and heirs. Then the loss of assets. The malicious conduct can result in the loss of assets either through theft or mismanagement, and can leave the beneficiaries with less than they are entitled to. In other words, they're plainly diminishing the worth of the value of the estate. Legal action. Beneficiaries may need to take legal action to recover assets or seek damages for any losses caused by the executor's malicious conduct. This can be a lengthy and expensive process. For anyone who's not familiar with the law and the legal practice in South Africa, anything that ever entails involving a court or a master's office is a lengthy and expensive process. So naturally, we don't want to have to go that route, but sometimes it's necessary if your executor is not performing as they are supposed to in terms of their fiduciary duties. As is always the case, the person instituting the action will be burdened with the cost thereof up until the point where judgment is granted. So naturally, this is not a great consequence. Then emotional distress. Malicious conduct by an executor can cause emotional distress for the beneficiaries, who may feel betrayed or violated by the executor's actions. Like we said, a lot of people appoint their executor or a family member or relative as an executor, and obviously if these people go awry, it's even more so that you're causing emotional distress to the beneficiaries, because there's that trying to be nice by the beneficiaries and not really say to the executor in their faces that they're not doing what is best for the beneficiaries or the estates as a whole, and at the end of the day causing enemies to be created. Then damage to relationships. This ties into what I've said now. The malicious conduct can damage relationships between the beneficiaries and the executor, as well as between the beneficiaries themselves. This can be particularly difficult in cases where family members are involved. So what are our remedies? We've now looked at what is an executor, how they go awry, and now we get to the point in time where everyone wants to know, so what is the answer? What do we do? So the remedies are before the winding up of the estate. In other words, the process is still pending in front of the Master of the High Court. No money has been paid out. The remedies are first and foremost removal by the court itself. So that would mean an application to the court for the removal of this executor. So the Act sets out 4 grounds on which a person can be removed as an executor. So I'll just read them for you. The acts are usually written in a way that it's not very plain language. So I'll just explain a little bit on each one as well. So if the executor has at any time been a party to an agreement or arrangement whereby he has undertaken that he will, in his capacity as executor, grant or endeavor to grant to, or obtain or endeavor to obtain for any heir, debtor, or creditor of the estate, any benefit to which he is not entitled. So in other words, the executor is colluding with someone to give them some sort of benefit that they are not entitled to. So it could be in the form of a beneficiary getting a larger chunk that they're not entitled to, alternatively bringing someone completely new into the mix. Let's say, for example, someone lodging a claim that the executor knows well to be false, but admitting the claim and paying that money out, obviously for a cut. If the executor has, by means of any misrepresentation or any reward or offer of any reward, whether direct or indirect, induced or attempted to induce any person to vote for his recommendation to the master as executor, or to effect or to assist in effecting such recommendation. So in other words, you're not allowed to have someone back you or vote for you or vote you into power. This is not government. If he has accepted or expressed his willingness to accept from any person any benefit whatsoever in consideration of such person being engaged to perform any work on behalf of the estate. So this, let's give an example, would be someone has to sell the house that is in the estate, and now we're using an estate agent who's in some way or form bribed the master for that work. And then, and this is usually the clause on which most of these removals are based, is for any other reason the court is satisfied that it is undesirable that he should act as an executor of the estate concerned. So like I said, this is where most of our causes of action come from, is this clause. This would mean literally the executor doesn't do their job, as they haven't filed papers, or they are taking too long, or whatever the case may be. Usually someone will come to you in consultation and tell you, we're not happy with the executor, and these are the reasons. And these reasons usually don't fall into the first 3 categories. Usually it will be something completely novel to the merit of the matter, and then obviously that is elaborated upon, and this clause or this section is used as the basis of the application to remove this person as executor. Then we can also approach the master to remove an executor. I would highly caution against this, as the master is notorious for not coming back to people at all and not doing much of work. But it is a possibility in terms of legislation to approach the master for the removal of an executor. And the grounds for such removal is A, the will by which he was nominated has been declared void by the court, or the nomination has been revoked. So that one is quite self-explanatory. If the will is void, as declared by court, obviously that person appointed by that will cannot act as an executor. He fails to promptly with a notice. He fails to comply with a notice to furnish security within the specified period. Pardon my reading skills there. So in other words, literally sitting back, being lax, not doing what they're supposed to. As we discussed, security is quite critical, as it safeguards the assets in the estate. So it makes sure that we don't sit with a deficit in the estate if that is just due to the actions of the executor. Okay, he's convicted of certain crimes such as theft, fraud, forgery, uttering or a forged instrument, or perjury. As with most things, when you are dealing with or when you are appointed as a position of trust or in a position of trust, you can't have a criminal conviction, especially on basis of these specific crimes. Sometimes more crimes, but I mean, one would assume someone who's been found guilty of fraud or forgery isn't supposed to sit as the executor of an estate, especially dealing with someone else's money, I suppose. He becomes incapacitated to act as an executor. This would be merit-based. why he would be incapacitated. So it really does depend on the merits of each matter. He fails to perform his duties or comply with the lawful requests of the master. And then he applies in writing to the master to be released from office. So I'll get back to E. Let's just quickly deal with F. So obviously, if this person doesn't want to be an executor anymore, he can resign as such. That is quite okay, and that's obviously a reason for the master to remove him as the executor. And then when we go back to E, this is usually the ground on which you would launch to the master to have an executor removed, or apply to the master to have an executor removed. They don't comply with a lawful request of the master, i.e. they don't, for example, file the liquidation distribution accounts. But the bigger thing is they fail to perform their duties. So usually when estates and litigation are involved, it's because someone is aggrieved, because the executor has not done as they're supposed to, for X, Y, Z reasons, and that's usually under which clause that application to the master would fall. Then an interdict always applies. So you can also approach the court for an interdict to have the person removed, or to be interdicted from performing the duties. So beneficiaries in South African law can seek interdictory relief against a malicious executor. An interdict is a court order that stops someone from carrying out a specific action or requires them to take certain steps in order to prevent harm to others. An interdict can be used to prevent a malicious executor from continuing to act inappropriately and protect the beneficiary's interest. And then to obtain an interdict, and which is quite a heavy duty, a burden of duty to carry in terms of an interdict. But anyway, to obtain an interdict, the beneficiary must show that there is a prima facie right for the relief sought, a well-grounded apprehension of irreparable harm if the relief is not granted, and then the balance of convenience must favor the relief. Yeah, so those are, let me just go back there. Those are the three manners in which to approach either the court or the master in order to have an executor removed. My suggestion would always be to approach the High Court rather with an application to have them removed rather than the interdict. As I said, the interdict does have quite a heavy burden of proof that it carries with it. Then after the estate has been wound up, in other words, all the paperwork has been filed, the money's been paid to the beneficiaries, all is well. Sometimes all is not well. And then either the person becomes aware of the claim against the estate, or the malicious actions by the executor after the fact of the winding up. Alternatively, they weren't in time before the winding up of the estate to bring their action. But obviously you can still bring your action to either the High Court or the Magistrates Court, depending on the quantum of your claim, for damages against that executor. So first and foremost, the burden of proof would be for the beneficiaries to prove that the executor acted maliciously and breached their duties and caused them financial loss. Secondly, a breach of duty. So one still has to prove that the executor did not perform their duties as outlined in the Administration of Estates Act or the common law in terms of the will. Then there must be negligence on the side of the executor. They fail to exercise the standard of care that a reasonable person would in similar circumstances. So this is the standard burden or the standard test in terms of negligence is what would the reasonable person in the same circumstances, what would that person have done? So you have to show, obviously, that your executor acted unreasonably. Then causation, the beneficiaries must prove that the executor's breach of duty or the negligence caused them loss. So you actually have to prove there's been a financial loss to yourself in order to substantiate your cause of action. Then remoteness, the loss must be a direct consequence of the executor's breach of duty or their negligence, which goes without saying, but I mean, you can't be claiming for someone else's actions against an executor. The damages must be proven, i.e. the amount of the loss, and that was a direct foreseeable consequence of the executor's breach of duty or their negligence. Contributory negligence. Sorry, guys, my second language, English, is failing me. If the beneficiaries contributed to their own loss, in other words, they performed some duties or they performed some actions or they omitted to perform some actions, which has now resulted or has contributed to their financial loss, their damages could be reduced accordingly. So the court would usually do an apportionment and say, listen, you were 20% responsible for the damages caused. The executor was 80% responsible, so obviously only 80% of your claim would be allowed. And then mitigation, this is important in most aspects of the law, is the beneficiaries have a duty to mitigate their loss. In other words, they have to take reasonable steps to reduce the extent of their loss. So a good example of this would be during the administration of the estate. Obviously, you need to speak up and you need to be informed and you need to keep yourself abreast of what is going on. If one just sits back and has everything just go haywire and could see you could see the damage coming up, then obviously there could be a mitigation factor that has to be taken account of.